Well, hello.
And welcome to the Hildebrand Law Firm topic for today.
Today, we are going to focus on a topic that comes up much more frequently than you would ever guess, and that is dealing with estate planning relative to disabled children or other beneficiaries that are disabled.
And a really common question that I get, Kirsten, when I have a client in my office, they say, I have two kids that are totally fine, no issues. I do have one child that's disabled. I have a child who has autism. I have a child with a different form of disability. Should I just leave nothing to that child? And I always tell them, I would recommend against it. You can leave that kid money. So let's talk about how we can do that.
I think that's really interesting. And before, I would say many moons ago, when I was doing a more simple form of estate planning, because the world was a little bit simpler at that time, I would always ask people the question, do you have a child with a disability? And then it occurred to me in the constant development of the practice that, in fact, you don't know when you may possibly have a child who is disabled. In fact, you could be 95 years old in a nursing home, and all of a sudden, a child that you never thought would qualify for disability ends up qualifying. And so I think we need to start with what is the definition of meeting the medical definition for disability under the Social Security Administration Act. And in short, number one, you can't be working. And number two, the medical condition has to be severe. And so what that means is that it is not something that's temporary. It's not something that it's expected to resolve. It's something that involves your major life activities, and it's going to basically inhibit or harm your ability to do things like walking, sitting, standing, lifting, remembering. And it also has to be something that is a problem that is severe enough that you will not be able to fulfill work activities. So there's a huge process for getting yourself qualified as disabled under these circumstances. And sometimes people don't qualify, but they still have issues that you may want to handle in your estate planning, even if they don't qualify as receiving disability benefits under the federal act. So already, Matt, I think I'm sensing we're going to have to do two parts to this.
Yeah.
Because I think during this session, let's focus on when somebody is truly qualified and how do we handle that in an estate plan. And then I think secondarily, what do you do when somebody, in your opinion, should have qualified, or in your opinion is not capable of managing an estate or managing an inheritance? And is there something to help out with that situation?
Sure. So for part one, pretty easy to determine part one. Most of the time, people will come to me and they'll say, I have a son who's on disability benefits. I have a daughter who's getting disability every month. Maybe they have a child who's even in housing. They get health care. Maybe they have a stipend. Maybe they have some sort of a work opportunity. There's an entire apparatus that is built around the disabled individuals to make sure that they have a comfortable way of living, despite their disability, which clearly they didn't ask for. And so we as a society have built it up in such a way that they can still participate, they can still, be a benefit to society, even though they are less fortunate than others. And so with that, the big question that I always get is, Matt, if anything happens to me, I don't want to leave my disabled son anything because he's getting all of these benefits that are so helpful and so lucrative over the course of his life. If he just gets all this money, he's going to get kicked off of his benefits, right? And the answer is yes.
Yes, it is true. And at the same time, the other question is, well, then what do I do with these funds that I would love to make sure go to the disabled child or beneficiary so that they can have a higher quality of life? This reminds me of a client who came in not so long ago, and it was a elderly husband and wife who had been taking care of their fully disabled son for a long period of time. He was actually in a facility, and they told me, well, we haven't left anything to our son because we know that then he will get removed from his benefits, and the benefits are paying for the home. So we've decided to leave everything to his sister, Betty, who, by the way, was already in her 80s. And we're going to leave everything to Betty. And Betty has been instructed by us what to do to make our son's life more comfortable. Now, I don't think we can think very far down the line to figure out what's wrong with that picture. Let's just list off all of the possible things that can go wrong.
Sure. So, first of all, you give someone a whole ton of money. I know you give them instructions, but you give them a whole ton of money and say, take care of your brother. How often does that actually happen? Hopefully, more so than our skeptical minds want to think. But unfortunately, the problem that we see here in our conference room all the time is that they don't help out the sibling they're supposed to help out because people get a whole lot of money, people don't get a whole lot of restrictions. They kind of run with it.
Especially when it's oral. I
Right.
mean, they don't even have to admit that the transaction actually happened or that there were any oral promises at all because the person that they made the promise with is now deceased. And the other thing that, of course, we're not thinking about when we make these decisions is a person may, in and of themselves, have very good intentions, but we don't know when that person may have other people in their lives that come into play. And of course, we don't know whether they can be influenced potentially by those other individuals and have a shift in their thinking as a result of that. Maybe a child needs to go to college and it's what, $70,000 a year? And all of a sudden, this is the only way to get that child to college. And well, it doesn't matter anyway because the disabled person is just fine, or that may be the rationale. So that's just one element that could go wrong. I can think of another one. The person who is the recipient of the beneficiaries funds could have an accident themselves and or have liability that they incur themselves, and now all of a sudden that money that was intended to go for the disabled individual is going to get tied up in litigation and possibly be used as compensation for whatever occurred.
Right. Or, what if that person goes through a bankruptcy? What if that
Yes,
person gets divorced? If that person goes through a bankruptcy, they're not going to go to the bankruptcy court and say, "No, Your Honor, this 100,000 is for my disabled brother, so that's not up for grabs, right?" And the judge will say, "Oh, it's certainly up for grabs. That 100,000 is in your name." So,
that's right. There's no rule that allows that bankruptcy judge to implement an oral contract based on hearsay.
right. And so this brings up a kind of a conundrum because you want to trust one child to take care of the other child for sure. But if you want to guarantee that whatever your wishes are going to be followed through, you need to put it in writing, and there's a few different ways to do it. The first way that I want to talk about is a third party special needs trust.
Mm-hmm.
We do a ton of third party special needs trusts. All it is, and it sounds complicated, but it's actually very simple. It is a separate document that you set up and you say, here's what my wishes are. I want you to take care of my son with whatever money I put in an account in the name of this trust. I want you to give him perhaps X amount a month, maybe X amount a week, whatever you decide until that money runs out. Here are the things I want you to provide him help for. I want you to provide him help for, anything ancillary to what his benefits, because the main thing that we're trying to do is we want to supplement benefits. We do not want to replace benefits. We want to supplement someone's way of life without replacing the benefits. The benefits are so important.
And of course, the reason for that is because if the government understands that there was an inheritance and there is a direct inheritance, then that will kick them off their benefits. However, the writing and the particulars of the third party special needs trust is so important because there are certain rules that must be followed. So if the benefit provides for something that is supposed to be provided for by the federal government through the benefit program, then there could be litigation that ensues as a result of that. So the drafting of a third party special needs trust is really, really important. Otherwise, it could upend the whole structure that we're trying to put into place.
Right. And then another question that people ask, they say, okay, well, right now I have kids that are totally fine. I get a lot of, I get this all the time. I'm not worried about anything with disabilities. My kids are totally fine. They're in their 30s, they're doing great, no issues. The problem is that we don't know if any of us are going to have an accident, have some sort of an issue, and become disabled. We don't know. And so then the question is, well, then does everybody need a third party special needs trust? No, everybody doesn't need one. But what you should have is you should have some contingencies in your regular estate planning that you already have in case this ever happens. So, Kirsten, do you want to talk to them about third party special needs trusts or contingencies with regards to that?
So the solution that we've developed here is we literally put inside of every single one of our trusts what I call a what if trust. And the what if trust is, what if when the beneficiary passes away, that there is in fact something that has happened that wasn't anticipated that does cause that person to be disabled. There is a what if third party short form special needs trust inside of our trust that can be used by the trustee and funded by the trustee so that then there's no surprises and nobody gets kicked off their benefits. This is actually very powerful and very important to make sure that your estate plan has that inside of their trust. Well, I think that this is everything relative to a third party special needs trust with respect to people that have a medical condition that qualifies them as being disabled and they are receiving benefits. So thanks so much for joining us. And we are really interested in making sure that we are always protecting your today and your tomorrow.